This meeting of the Louisiana Tax Commission is hereby called to order. This meeting is being held at the offices of the Louisiana Tax Commission at 1051 North Third Street, Suite 225, Baton Rouge, Louisiana. The date is Wednesday, May 17th, 2023, and the time is 10:01 a.m. Please call the roll.
Chairman Shahardi,
Here.
Commissioner Potier,
Here.
Commissioner Jeffers,
Here.
Commissioner Vercher, Commissioner Wood,
Here.
4 present and a quorum.
Thank you. There being no old business to take up at this time, I'll accept the motion for the approval of the minutes of the May 10th, 2023 meeting.
Mr. Chairman, I move approval of the minutes from May 10th, 2023 meeting.
We have a motion. Is there any objection to the motion? There being no objection to the motion stands adopted. We'll now consider change orders.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 320 change orders. Staff has reviewed those change orders and requests to approve 308 and keep 12 in pending status. We'll place 12 in pending status. Staff requests approval of these change orders.
Mr. Chairman,
Yes.
I would move that we accept the staff recommendations and approve 308 change orders and place 12 in pending status.
We have a motion. Is there any objection to the motion? There being no objection to the motion stands adopted. We'll now consider prior pending change orders.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 79 prior pending change orders. Staff has reviewed those change orders and requests to approve 45 and keep 33 remaining in pending status and deny 1 in Cattle Parish per the assessor's request. Staff requests approval of the prior pending change orders.
Mr. Chairman,
Yes.
I move that we accept the staff recommendations to approve 45 change orders and place 33 in pending status and to deny 1 for the reasons given.
We have a motion. Is there any objection to the motion? There being no objection to the motion stands adopted. We'll now consider tax sale cancellations.
Chandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 3 tax sale cancellations, 1 in Cattle Parish due to being sold in error, and 2 in East Baton Rouge Parish due to being sold in error. Staff is requesting approval of the 3 tax sale cancellations.
We have a motion.
Mr. Chairman, I move approval of 3 tax sale cancellations based on staff's recommendation, 2 in East Baton Rouge Parish and 1 in Caddo Parish.
All right, we have a motion. Is there any objection to the motion? There being no objection to the motion stands adopted. We'll now move on to the appeal portion of our docket. I'd ask everyone who's going to testify at the microphone to please raise your hand to be sworn in as a witness.
I do, Russell Amaros.
Cody, please raise your right hand.
I do, Cody Lowry.
That'll work. Thank you.
All right. We'll take up the appeal of the Crescent City Apartment Rentals LLC versus Assessor Errol Williams and Orleans Parish Board of Review, docket number 22-22176-007. No representative or taxpayer here on behalf of the taxpayer. So we'll ask the assessor's office to please tell us about the appeal from their perspective.
Yes, sir. So this property is a property located in the South Broadmoor neighborhood. Our initial valuation of the property was $316,000. It was upheld by the Board of Review. It was appealed by the taxpayer, and the appraisal by the staff is within 2.5% of the Board of Review's value, which supports our initial valuation. We're asking the commission to uphold the Board of Review's value.
Give me one moment. I know that this property has a basement in it. Are you familiar with what may be in the basement?
Yes, sir. So the assessor's office received an appraisal form or sketch by the taxpayer because he's claiming that the basement should not be considered as living area. However, the appraisal sketch given to the assessor's office shows that the property has been built out, fully conditioned, has a bedroom, living room, dining room, all in that bottom floor. It's, the photographs show that the property is actually a living area and, should be considered, living area. There is an unfinished portion of that, which is a laundry room. And we've actually deducted that from the square footage. And I believe also the staff's appraisal, they went and physically measured and documented the property, shows that the basement is finished out with kitchen and sofas and TVs. There's actually people living there.
And there are people living
Yes,
in
sir.
that basement area?
Yes, sir.
Okay. All right, are there any questions? And you're requesting that we uphold the board of review?
Yes, sir.
Okay, thank you. Mr. Lowry, you want to tell us about your appraisal?
Yes, sir. Cody Lowry with the Louisiana Tax Commission. I personally appraised the property at 4422 South Johnson Street in New Orleans. When we appraised it, I utilized the income and market approach to the value and came to a fair market value of $325,000 with an undisputed land value of $49,300 and an improvements valued at $275,700.
Are there any questions for Mr. Lowry?
Can you describe the condition of the living quarters in the basement?
Yes, ma'am. The front half of the basement was finished out in a way that had a living room, a dining room, a kitchen, and 2 bedrooms and a bathroom. They were, I would say, in average condition, 7-foot ceilings. They had 2 tenants that were down there and present when I was there. And like the assessor stated, the back half of the building was an unfinished area that we categorized as storage. And we did not add in the unfinished part into our square footage either.
So you made an adjustment to the total square footage by reducing the total square footage by the storage area.
Yes, sir.
Thank you. All right, thank you. Any questions? All right, it seems that property owner or taxpayer is here. I'll have to ask you to please stand up at your chair to be sworn in as a witness.
The light is on. Is it working?
All right, Mr. Maurice, I'd ask you to talk close to the microphone and tell us about the property.
Excellent. May I ask Mr. Lowry some questions first?
Oh, I'd like you to present your arguments first. I'd like you to tell us what you can about the property and why you believe the value should be different than what the assessor or the tax commission appraiser says.
Yes, sir. Thank you, Mr. Shahardy. My name is Mark Maurice. I've been working in construction with my father and on my own as a licensed state contractor for many years, carry a license. I'm familiar with building and buildings and property measurement, and more importantly, familiar with measuring with a tape measure. This particular property is a severe repetitive loss property located in the Broadmoor area. It was not built as a duplex or a double family residence. It was built as a single family residence. It remains a single family residence. You can enter through the one front door and go through the entire building, front to bottom. Every part of that place is one residence. During the past 15 years that I have owned this single family residence, we have one address, one water meter. There is one family that has been there. Right now downstairs, there are students of a friends of mine that are there that are staying inside of that smaller area. But it's a temporary, because over the last 15 years, for about 20% of the time, it's not been wet or flooded. So it's only been livable for, I'd say, 20% of the time. It is a single family residence. And let me state, there's one water meter, one trash can, one address. And as a single family residence, it is my understanding that any space under 7 feet cannot be used in the calculation for square footage. The first floor, I hit my head on the beams. I am 6 foot, 1.5 inches tall. I don't believe Mr. Lowry can produce a single photograph that shows any part of the first floor over 6 feet, 4 inches tall, because it's not. Even the beams I hit my head on because they're below 6 feet inside of that area. My understanding as a builder is that when a portion of a property is built as an income producing property, you would have 2 addresses, or you would have 2 meters, you would have 2 front doors, you would have access to the street from both units. And the understanding that I have from ANSI, the American National Standards for Single Family Residential Buildings, and for construction, is that if you're going to use an income approach, you must have a building that is built for income. This is not built for income. Moreover, if you're going to use an income approach, you must have a building that is susceptible at all times of generating income, not just 20% of the time, because it is a severe repetitive loss property with mildew and water issues being in the Broadmoor area. Another understanding of mine is that your regulations and the regulations adopted by the state of Louisiana and the American National Standards for Single Family Residences demonstrate that you must use like in kind properties from the parish that you are actually going to be appraising. In Orleans Parish, Mr. Lowry has pointed out 5 or 6 different houses he used in his document to demonstrate their similar value. In Mr. Lowry's document, there are 2 homes which are like this home, built up and then later built in on the bottom. For the purposes of Mr. Lowry's exhibit, he did not include any of the first floor square footage on either of those homes. The homes that Mr. Lowry pointed out inside of his documents, which did not include, and I must say the city of New Orleans does not include the first floor of either of those. And let me, if I can, get those exact addresses. I do have photographs because I would like to question Mr. Lowry on whether he did any inspections prior to using the documents. They might be sitting on the dashboard of my car, but let me just get his appraisal so I can point out these 2 homes, because I think they are sitting on the dashboard of my car. Mr. Lowry's appraisal is here. If you may point out that Mr. Lowry brings to light two houses in his appraisal, one of which he has a photograph of, which is at 452729 South Rochambeau Street. I would like to point out that all of Mr. Lowry's comparable income approach and sales approach properties have two addresses, not just one. I'd like to point out that on 452729 South Rochambeau, it is a raised house with a built-out first floor. And if you look at the square footage of that property listed by the city of New Orleans and listed by the appraisers on the tax, on the sale prior, 4527, it shows that the above grade room count gross living area is 2,225 square feet. The document I have in my car is from the website of the City of New Orleans Assessor's Office, which demonstrates that if you look at this house, that they are only including the top floor of this house. In Mr. Lowry's assessment of addresses to determine a GLA, rent per square foot, in the GRM, he also lists 4 houses, all of which have double addresses. If you look at the website, which my house at 4422 South Johnson does not. But if you dig deeper into 3202 Jenna Street, you will find it is a raised house with a built-in first floor, enclosed, much like enclosed living space at 4422 South Johnson. You will also note that the City of New Orleans, the assessor for the City of New Orleans, and Mr. Lowry did not include the first floor square footage inside of that. So if this board is to consider a fair rental value, I believe that they should be apples and apples, because I think the whole purpose of national standards and regional standards is to compare houses that are similar in sales or income. 3202 Jenna Street rents for 85 cents a square foot. I have submitted as Exhibit A square footage appraisal. I have 7 copies. I believe I needed those. It shows that the square footage at 4422 South Johnson is under 2,000 square feet. I think it said it was 1,969. That is a certified appraiser. I note that when I look at the documentation for Mr. Lowry, that he has a temporary license. He has not been given his full license as an appraiser. The appraiser I use, Mr. Otis Shipman, is a fully licensed appraiser, does not need to have any type of agent or mentor. I note also that Mr. Lowry appraisal does not have the signature of his mentor or his supervising agent. I note that the board rules for the Louisiana Real Estate Appraisers Board Commission mandate that the supervising appraiser sign all appraisals with persons like Mr. Lowry, who currently do not have their full license. I note that there is no explanation as to what approach was used for any of the 7 properties that are comparables. But if we're comparing apples to apples, the 2 that he pointed out that he wants you to use that have built-in single floors, neither the City of New Orleans nor Mr. Lowry included the first floor. In this property at 4422 South Johnson, if we are going to follow the rules related to
Okay,
ANSI
Mr.
standard
Mr.
details.
Maurice, let me ask you.
Yes, sir.
This is all good and fine. I'm looking at the appraisal that was attached to your appeal. This does not appear to be the entire appraisal, is it?
It is. It's just for
So you
square.
did not hire the appraiser to value the property?
I did not, just for square footage, and I would submit to this board, I will use the square foot value Mr. Lowry chose or the rental value Mr. Lowry chose, as long as we have the appropriate square footage. I will submit that we can use Mr. Lowry's not 85-cent valuation, but the much higher valuation for rental value if this board chooses, or the square footage value if this board chooses, even though I believe it's an overestimation. I believe that coming with a give and take to the board, demonstrating that there's an absolute number that we have for square footage, and then conceding, rather than getting into the hay and the details, that Mr. Lowry's numbers could be accurate for the rental value or for the square footage value. Either of those applied to the proper square footage will give me the relief that I've been seeking from the beginning of this process.
So you're requesting a value of $211,700 on your appeal form. You think somebody made you an offer for that amount of money, they would be making a fair offer to you to purchase the property?
Knowing what I know about the property, yes, sir.
Okay. All right.
And after inspections, yes, sir. I mean, I can go into the details of the problems and
We're here to determine value, so you've got to get concise and tell us exactly what you think the value of the property is and how you get there. So that's really what we're interested in.
okay. Let me use my calculator. Chairman, thank you. If we use Mr. Lowry's market value with all of these houses combined, and then we use the subject square foot of 2,000 square feet with a rent per square foot of $1.10, by the multiplier, the GRM multiplier, it comes out to $244,200.
So how did you calculate that?
I used 2,000 square feet.
All right, what about the other 688 square feet that's listed on his appraisal?
His appraisal does not take into consideration any local or national standards.
Is the square footage of the property 2,688 square feet?
No, sir. The square footage is under 2,000
Of the whole property?
of the entire property. You can't count a finished basement with.
I didn't ask that.
That's what I'm saying.
2,688 square feet, the total square footage of the property.
No, sir. The total square footage according to Otis Shipman and according to standard is less than 2,000 square feet. I believe
Does that include the entire basement?
it includes the entire basement under the American National Standard for
I'm
single
not
family. Yes,
interested in
sir.
that. I want to know if it includes the entire basement.
It does for,
Anybody's standards, if somebody goes with a tape measure and measures the basement from the outside, or from the interior, it doesn't matter. 6 of one, half a dozen of the other. Does that include that number totally? You're asking us to exclude the basement, but yet the basement is fitted out. I mean, the pictures I see show a living area in that basement. So if there's a living area in that basement, it's got value to you.
and I'm not going to argue with you, Mr. Hardy. I believe that the law speaks for itself on whether or not it can be included inside of the living area estimate. I think
So
the
you're
law,
saying that if a property owner utilizes this area similar to yours to its fullest extent, he's got a 110-inch flat screen TV that he loves watching football on and basketball and baseball. Got a nice sofa down there, got a refrigerator, got a sink, have a bathroom. We should ignore that.
I'm saying that the guidelines promulgated by people much smarter than me, adopted by the United States, ignores it because it's under 7 feet. I'm saying that the
Well,
rules that
maybe
are,
that area shouldn't be used at all. Maybe it's in violation of the law. I mean, I don't know that it is, but the fact is it's built out, or a major portion of it is built out. It's got furniture, it's got I believe I saw like a kitchen area, and there's a bathroom in there. So somebody can physically be there and enjoy that area like you enjoy any other property.
well, not really, sir. It's a severe repetitive loss property with flooding. It's been used about 20% of the time. It does not fit into any definition of permanent use. In addition, if you look at definition of finishes, which talk about how you calculate square footage, the finishes have to be the same. I've got 10-foot ceilings on the first floor. I've got 5 to 6 foot 4 inch on the second floor. Those finishes are not the same. How do we value two houses next to each other if one's got 10 and 4 foot or 10 and 5 foot ceilings and one has 10 and 10 and you have the exact same square footage? It's the country has adopted a standard that says it's got to be apples and apples. Even the city of New Orleans with the two comparable properties do not include the first floors of the houses that are in the same neighborhood that are built in because they are not included in New Orleans. Normally, it's demonstrated by the documents you have in front of you. So just because someone puts a TV inside of a wet basement that floods every other year does not mean you include that space according to the American National Standard for Single Family Homes. And the ANSI, just as a point of reference, was created by or promulgated by the Louisiana Home Builders Association before it became a national standard. The Louisiana Home Builders Association brought this up. So not only is it something that the country uses, but it was started here in Louisiana. So I didn't make the rules, but I know that if I have a house next door with 10-foot ceilings and 10-foot ceilings, that's 2,000 square feet. And I have a house over here that's 10-foot ceilings and 6-foot ceilings. And the appraiser says they're exactly the same. We're going to value these exactly the same because 10-foot or 6-foot, it doesn't matter. Every document on the issue as a contractor, as a builder, as a buyer, as a homeowner says you can't do what Mr. Lowry is doing. You can't do what the city of New Orleans is doing. And both of them seem to acknowledge that by placing raised homes with half, only counting the upstairs, half of the square footage. If Mr. Lowry didn't acknowledge that, he wouldn't have half the square footage on this house that he listed or both houses. If the city didn't acknowledge that, they wouldn't list those houses that are raised at half the square footage. Why would 4422 South Johnson be treated differently than what Mr. Lowry says is appropriate and what the city says is appropriate and what my certified appraiser has come back as a professional appraiser and said appropriate? Mr. Lowry's document is inadmissible as it does not have the signature of his agent, that's supervising agent. Every one of his documents, every one should be submitted with the supervising agent. I can cite the Louisiana Real Estate Appraisals Board document, which says that if the board needs to see that. But I can tell you, Mr. Lowry did not take a single measurement from downstairs. He mentioned 7 feet a moment ago, and I hope he was under oath because he didn't take a single measurement downstairs. There's not a single portion of that house that is above downstairs, which is near 7 feet. So it doesn't calculate that way. But if we have 3 houses next to each other, Mr. Shahardy, one's got 12-foot and 12-foot ceilings, and one's got 12-foot and 6-foot ceilings, I don't believe anyone here would say that you can count all the square footage as the exact same. My answer is based upon what the national standards are and what the Louisiana Home Builders Association uses and what the city has used on the comparable properties, demonstrating they do not count the first floors in the city of New Orleans by the 2 properties they have listed and Mr. Lowry has listed.
All right, thank you. Mr. Lowry, you've been the subject of a lot of conversation. So do you want to give us any more information?
Yes, sir. I'm 6'3". I did not have to duck in this basement. There was very about half a foot of clearance between my head and the ceiling. So it was 7 feet. There, when I went down there, I pulled a measurement outside of the room we were standing in, and it came to 7 feet. When we were in the basement, the only section that I measured that I've included in my appraisal is the section that was finished out. The rest of the back half of that building, which was a little bit more than half of the first floor, we listed as unfinished. We included it as storage and as laundry room, did not include it in the square footage. When we did the measurement of the upper floor, it came out to be a 32 by 59, which is approximately 1888 in square foot. And then when we added in the bottom part, it was a 25 by 32. So it added about 800 square foot, which is where we came at the 2688. Now he's stating the ANSI standard. The ANSI standard states that the minimum requirements for a livable area is 7 feet. A city ordinance code states that the minimum requirements is 7 feet, unless there is at least 50% of it. At least 50% of it has to be at least 7 feet. I have these codes with me. The current ANSI standards by Fannie Mae states that at least 50% of the finished square footage of the room must have a ceiling height of at least 7 feet, and no portion of the finished area has a ceiling height of less than 5 feet to be included.
And the property fits that definition?
Yes, sir.
All right, thank you. Mr. Alvarez, you've been talked about also in this conversation. Do you have anything to add?
Oh, I do have a couple of things to add. I just was just gonna wait. I believe that the taxpayers misrepresenting the comparables. He's claiming that the city is not adding the bottom floor, which is hearsay because he's provided no documentation to that fact. I can tell you for a fact that the assessor's office includes all livable square footage in all of our square footages. So we're not discounting someone else's first floor and not discounting his first floor. I could also state that the property owner is going on and on and on about his property being a single family residence and all the other properties being a multifamily residence. I don't know if he's aware of the fact that multifamily residences are usually valued at a lower rate than a single family residence. So if that is the case, then yes, that would also mean that this appraisal is low and it should be a lot higher because a single family residence would command a lot higher value than a multifamily residence. And also one last thing is the documentation or exhibits provided by the taxpayer was not submitted to the assessor's office until last week. So if there's any inadmissible evidence, it would be the taxpayer's exhibits.
All right, thank you. Does anybody on the commission have any questions for the parties? Yes, sir.
Am I going to be allowed to ask questions, Mr. Chairman?
Sure, you can ask questions.
I have a question. How many tenants do you have?
Right now, I've got upstairs 3 tenants, and downstairs are 2 tenants.
How many leases do you have?
2 leases.
But you want to say this is one property because you have low ceilings and you want to get paid to have these people on the bottom floor, but not pay property tax. I just want to be clear on that.
No, ma'am, that's not correct.
You're not receiving money.
No, I'm receiving money, but that's what you laid everything out is not correct. The standards that I'm using are the standards, right? Mhm. Yes, ma'am. The rationale is that for 20% of the time, over the last 15 years, I've been able to go ahead and put someone downstairs. So the finished areas must be suitable for year-round use. It's not suitable for year-round.
So
use.
is this a month-to-month lease and they have to leave if it floods? I guess I'm trying to
That's-
figure.
That's correct.
Now, we don't have any, did you submit any evidence to show that it floods?
Don't have a copy of the lease, and the evidence is going to be my testimony. It's a severe repetitive loss property under the federal standards. It floods it. You can see the sandbags sitting outside in the photographs of the property on the first floor. So there are sandbags, but I have an email to Mr. Alvarez on April 13th at 9:04, which has the report of Otis Shipman. Mr. Alvarez just stated under oath, I'm sure, he only received it last week. Here's an email demonstrating that he received it on April 13th, 2023, to the email address which I have used to always reach Mr. Alvarez. Would you like to see the
Was it submitted to us? Okay, then I'm not interested. I mean, we can't accept it. It's got to be submitted to us.
I can use it for cross-examination, right?
You can ask any question you want. It's just that it's not supported by any evidence.
Okay. Mr. Alvarez, is this an email sent to you on 13th?
I have no recollection of this email to me on the 13th. I called you specifically to see if you would withdraw your appeal. You said that you had an appraisal. I said I had not received it. You sent me an email of an appraisal sketch and not of an appraisal.
Well, that's the same document you received, which shows the sketches in the square footage. It's an appraisal for the purposes of square footage only. Like I stated earlier, I will accept the commission's determination of fair rental value or square footage price under the national standards of how to measure a house and under the standards of how they measured two other houses in the same neighborhood without including the first floor. I'd also like to mention Mr. Lowry stated that he's 6'3" and he had about a half a foot on top of him. He also, which is 6'9" inside. He said that he pulled a measurement outside of the area, which came to over 7 feet. But he did not and cannot swear under oath that he pulled a measurement inside of any of the first floor that was 7 feet or above, because there's not a single portion of that house that is 7 feet or above on that first floor. The last thing I'd just like to point out to the board is that the methods for calculation square footage, which are being used, are used by Fannie Mae, Freddie Mac, United States Census Bureau. They're used by the federal government. They're used in loans. I could not get a Fannie Mae loan on this house at anything more than 2,000 square feet. It can't happen because they would not consider the first floor under the regulations. U.S. Census Bureau is not considering a separate floor or separate living for this in their determination because the whole floor on the first floor is under 7 feet. It's not something, if it was a consistent income commissioner that was with me every day that I can rely upon, then I would not be here asking for an appropriate rental value. Because generally speaking, they come, it rains, they go, it takes time to go ahead and get it fixed. I get somebody else back in there.
But they're there at some point, which gives value, and you've brought nothing to show us when they're there, when they're not there, how much you get. We don't have any leases. We don't have any evidence that shows any of that. And you have value in it, in my opinion.
Well, I don't dispute that at all. I mean, in my bank account will reflect it when they pay me that there's value there as well. But if we're going to do that, then use 85 cents, the comparable property, as the rental value, not $1.11. I mean, all I'm trying to do is get apples and apples here. They can't say, well, we're not going to include the first floor of any of these houses for any valuation purposes, even though I know they're rented. I know there are people down there because I've been inside the houses. But the fact is that they can't exclude the first floor of similar houses in one area and then give you a calculation of 85 cents for the ones they're excluding and then use a higher rate for my house.
That would be an equity argument. In order to make it, you would need to bring those, you would have had to file that as an exhibit, because that's an argument. If that's happening, it's an equity argument. But we don't have the evidence here for us to see that. We have your testimony But in order for us to be able to actually know that what you're saying and see the facts, just like you gave us the square footage appraisal, we would have had to have that information. And we don't have it. We don't have the exhibits.
Yep, well, and so my testimony is uncontroverted on these issues. I can ask if Mr. Lowry inspected any of these houses which he listed, and I believe he did not inspect any one of them. We can go down the train to show that I've had my eyes on it, and I've visually been there, and I know the houses where Mr. Lowry has not. We can also look at his document report and demonstrate that the Louisiana Real Estate Appraisers Board does not allow him to submit documents like he did without the person who is his oversight agent signing it. And it's been submitted here as well, which I would object to the introduction of it as well. I agree. I'm just trying to find a fair middle balance. That's why I said I'll go with his numbers for square footage. I'll go with his numbers for rent. Just please go with the number that I would have to use. If I were to list the property tomorrow, I have to use 2,000 square feet. I'm not allowed to use any more than that. If the census comes, if I have a Fannie Mae, I can't use it. The homeowner can't come buy my house at 2,600 square feet. They can't get a loan for that because it's not it doesn't meet the standards for inclusion of calculation. So if the whole issue is what would a fair transaction, Mr. Shahardy, be from buyer to seller, the homeowner can't get an appraisal for more than the amount of livable square feet under the FHA or Fannie Mac or any of these other standards. Because someone is there right now or for 20% of the time, I shouldn't be penalized for that.
Well, again, as Commissioner Wood said, we don't have any evidence. Much of what you're saying, we have no evidence of. No, nothing was submitted to us, evidence-wise. So,
Now, I would submit that my testimony here after being sworn in is evidence. I would submit that it's uncontroverted because he's not taken any measurements inside. He's admitted he's 6'3" and the ceiling was 6 inches above his head, which is under 7 feet. I would admit that his evidence of the documents which he provided to you demonstrate the first floors are not being used in calculations for these different houses. I would submit that he gave you everything you need to exclude the first floor here. But in addition, I've submitted Mr. Owen Shipman's just square footage calculation. I didn't want to argue about the sale of a square foot or the rental value. The United States, the federal government, the Census Bureau, they're not going to allow me to include, if I go to sell the house or somebody wants to buy it, that first floor area. And so I'm here asking for the commission to consider that in their decision.
all right, thank you. Is there any more questions from the commission? Do we have a motion? Silence means I'm supposed to make the motion. All right, with regard to the appeal of Crescent City Apartment Rentals LLC versus the Orleans Parish Board of Review, docket number 22-22176-007. My motion is to affirm the value established by the Board of Review. Land 49,300, improvements 266,700 for a total fair market value of $316,000. Is there any objection to the motion? There being no objection to the motion stands adopted.
Thank you
Mr.
for your
Maurice,
time.
Thank you for coming,
Yeah,
and I'm
thanks
glad we
for-
were able to get you in.
Thank you for your time.
Take
I
care.
appreciate it. Thank you, Mr. Lowry.
All right, I believe that concludes our docket for today. Am I correct? All righty. All right, well, there being no other matters to come before the commission at this time, I will accept the motion to adjourn.
So moved.
We have a motion to adjourn. Is there any objection to the motion? There being no objection to the motion stands adopted, and we stand in adjournment at 10:45 a.m.